The other thing, sort of legally we're watching is the Monona County case, and we've talked about this in the past. That's the weed spraying issue where DNR sent an investigator in to investigate some spraying of weeds in a trustee-run drainage district, New Farmers Drainage District in Monona County. And the DNR alleged that the chemical that was being sprayed on the weeds resulted in a fish kill in the drainage ditch, and fined the Board of Trustees of the Drainage District and fined the spraying company and asked them to enter into a consent decree in which they would pay a fine, pay the cost of the dead fish, and basically turn over control of the drainage district to the DNR for a 2-year period of time. I mean, part of the consent decree was they would do nothing in the drainage district. The trustees would take no kind of action in the drainage district without first getting permission of the DNR for a 24-month period of time. And the trustees basically said, we've done nothing wrong and we're not going to cede control of our drainage ditch to the Department of Natural Resources, so we're not signing anything. That case went before an administrative law judge about a year ago. It was January of 2009. And for those of you who know how administrative law judge process usually works, they usually find on behalf of the state. Administrative law judges are state employees. They work for the Department of Inspections and Appeals. And they're hired to oversee contested cases that come out of the regulatory.
Why did that end up in that?
The law says that that's the first stop in the process, that you cannot go directly to a
district court.
To a court. You've got to go through the administrative process first. So we lost at that level, which we expected. It still saves me that we did, but nonetheless we lost at that level. What happens at this point is a little unclear, because one statute says that you go and appeal to the Environmental Protection Commission, and another statute says that you appeal to the Director of the Department of Natural Resources. Either way, it's sort of immaterial because we'll lose either one. Neither one of those venues is going to be a friendly venue to where we are in this case.
That's in most of the things that I'm familiar with, it usually goes directly to district court. I'm surprised at that.
No, I wish it could, because what our goal has been is to get this darn thing into court so that we get it out of state government and get it into an impartial kind of hearing process, you know, that can look at both sides of the issue. That's what we're trying to do. But so far we've got at least one more step before they can get it to that point. And again, my fear here is that, you know, we've seen legislative attempts by DNR to try and gain control of the drainage interest. They've not been successful at that because the legislature doesn't feel they should. You have a lot of bureaucrats within DNR that don't like drainage, that don't like the fact that it exists, that want to do away with it, they want to regulate it. And I think this kind of thing is a backdoor attempt to try and assert themselves on a regulatory basis over drainage and drainage interest. So we're watching this very closely. We're also providing financial support for them. And, you know, again, here you have, well, Calhoun County, $40,000. Here you have a case that, you know, depending on how far it goes, could be upwards of $200,000. And you've got the landowners that are standing firm and saying, we did nothing wrong, we want to stay with this, which shows you how staunch they are. So that is another one that we're watching very closely.
Landowners in the district, but the actual person was contracted that was doing the spraying. That was a contracted.
Yes. Yeah.
That's the same one we use, I think.
Down reefer.
Yeah.
That's the trouble with, I mean, anytime you go up against DNR, you know, you hire people.
Sure.
Like when we're doing the landfilling. The meter runs for us, and they're going off administrative rules and not, you know, passed by the administrative rules committee, not the whole legislature. Very little awareness.
Well, it's our contention, what we've been trying to do is get the drainage district out of that case. We don't believe the drainage district has any business there. I mean, the issue is, guy was spraying for weeds. The investigator comes in and sees dead fish and says, that chemical killed the fish. That's the whole point of discussion on this whole case. What killed the fish? Why are the trustees involved? I mean, all the trustees did was hire, and they did everything legal in terms of how they did the hiring. You hired a licensed contractor who's registered and certified by the state of Iowa. They followed the process that they need to do under drainage code to hire this individual. They did nothing wrong. Why are they even party to this case? And so the basis that we've taken going forward is if you're really concerned about this chemical, make it a fight between the state and the spraying company, which is basically represented by an attorney through the insurance aspect of it. And they're going to bring in their experts and make a decision based on that, not that the trustees were the ones that hired. I mean, it's ridiculous. It is. So we're watching that.